content of this podcast is intended for educational purposes only and does not constitute legal or medical advice. Laws vary by jurisdiction. Medical standards evolve. The case details presented are derived from publicly available court records, appellate opinions, and published reporting. Listeners should consult qualified professionals for advice specific to their circumstances. Over the last 2 episodes, we've covered what medical malpractice stress syndrome is, how it manifests, and why it can be fatal. And we've explored its connection to the physician suicide crisis. If you've been listening, you now know more about MMSS than most physicians will ever learn during their training. But knowledge without action is just awareness. And the research is clear on one thing above everything else. The single most protective factor against MMSS is knowing about it before you get sued. Not after. Before. This is part 3. Before you get sued. And today, we're going to talk about what you can do right now, this week, on your next shift, to prepare yourself for an experience that the statistics say is almost inevitable. The literature on MMSS consistently identifies one variable as the most protective: pre-litigation awareness. Physicians who understand what to expect from the litigation process, who recognize that the emotional response is normal and predictable, and who have support structures in place before a claim arrives, experience less severe symptoms and recover more quickly than those who are blindsided. Michael, why does knowing about MMSS in advance matter so much?
Because the core mechanism of MMSS is uncontrollable stress. And one of the most well-established findings in stress physiology is that perceived controllability is a major modulator of the stress response. When you can't predict what's coming, when you don't understand the process, when you don't know what's normal, every element of the litigation feels like a new threat. The summons is a threat, the deposition is a threat, the expert report is a threat, the trial date is a threat, and your stress response fires at maximum intensity for each one because each one is unfamiliar. But when you understand the process, when you know that a deposition is standard procedure, not a sign that you're losing the case, when you know that most cases settle and don't go to trial, when you know that the emotional roller coaster you're on has a name and a pattern and an endpoint, the threats don't disappear, but they become manageable. You shift from being a passive victim of the process to an informed participant, and that shift in perceived control is biologically what protects your HPA axis from the sustained activation that causes the cardiovascular and psychological damage we discussed in part 1. This is not abstract. The During Peer Support Study, the literature on cognitive reframing, the work by Louise Andrew on the 4 essentials, they all converge on the same conclusion. Knowledge is the first intervention, and it's the one that costs nothing and is available right now.
Sarah, one of the things that makes malpractice litigation so stressful for physicians is that they don't understand the process. Can you walk us through what a typical malpractice case looks like from the physician's perspective?
The timeline varies by jurisdiction, but the general arc is consistent. A typical malpractice case unfolds in 5 phases, and understanding these phases in advance can significantly reduce the mystery component of the stress response. Phase 1 is the pre-suit period. This is the time between the adverse event and the filing of a lawsuit. In most states, the statute of limitations for medical malpractice is 2 to 3 years from the date of the incident or the date of discovery. During this period, the physician may not know a claim is coming, but they may be aware of an adverse outcome and may already be experiencing what the literature calls anticipatory anxiety, the fear that a lawsuit is imminent. Some states require a notice of intent to sue before a formal complaint is filed, which provides early warning but also extends the period of uncertainty. Phase 2 is filing and service. When the complaint is filed and served on the physician, this is typically the most acute stress point. the physician receives a formal legal document alleging that they committed malpractice. The language is adversarial by design. The complaint is written by the plaintiff's attorney to present the strongest possible case for negligence. It's not a balanced assessment of the care. It's an accusation. And for a physician who has never been sued, reading that document for the first time can feel like a professional death sentence. Phase 3 is discovery. This is the longest phase, typically 12 to 24 months. During discovery, both sides exchange documents, medical records, and written questions called interrogatories. The physician will give a deposition, sworn testimony under oath in a conference room, with the plaintiff's attorney asking questions designed to identify weaknesses in the care or the defense. Depositions are, by most physician accounts, the single most stressful event in the litigation process. They are adversarial, detailed, and can last hours. The physician must be precise without appearing rehearsed, honest without being damaging, and composed under pressure that is explicitly designed to create discomfort. Phase 4 is expert review and pretrial. Both sides retain expert witnesses, physicians in the same specialty, who review the records and offer opinions on whether the standard of care was met. Reading an expert report that criticizes your care is uniquely painful for physicians, because it's not just a lawyer making an argument, it's a peer, a colleague saying you fell short. Pretrial motions, mediation, and settlement negotiations happen during this phase. The majority of malpractice cases resolve here through settlement or dismissal and never reach trial. Phase 5 is trial. If the case goes to trial, it typically lasts 1 to 3 weeks. The physician will testify, be cross-examined, and sit in a courtroom while their clinical judgment is debated by attorneys, experts, and a jury of non-physicians. Trials are relatively rare. Most estimates suggest only 5 to 10% of filed cases go to trial, but they are the most intense stressor in the entire process.
I want to add one thing to Sarah's timeline. There's a phase 6 that the legal literature doesn't talk about, but the MMSS literature does, the post-resolution phase. As we discussed in part 1, the evidence shows that symptoms don't resolve when the case closes. The Vizcaíno-Rakosnik data found no difference in psychological impact between open and closed claims. Physicians carry the effects of litigation long after the last court date. Understanding that expecting that resolution doesn't mean instant recovery is itself a form of preparation.
One of the most widely cited individual-level intervention frameworks for MMSS comes from Dr. Louise Andrew. She developed what she calls the 4 essentials, a cognitive reframing approach designed to combat the paralyzing helplessness that characterizes MMSS. Michael, can you walk us through these?
The 4 essentials are essentially a cognitive reframing toolkit, and they map directly onto what we know about stress physiology. The first is replace mystery with knowledge. The fear of the unknown amplifies every other symptom of MMSS. When you don't understand the litigation process, every step feels like a new threat. Learning the mechanics, what a deposition actually is, how discovery works, how settlements are negotiated, doesn't eliminate the stress, but it makes it manageable. It shifts your brain from threat detection mode to problem-solving mode, and that shift reduces the chronic HPA activation we talked about in part 1.
And this is where legal literacy becomes a clinical intervention. Physicians don't need to become lawyers, but understanding the basics, that a deposition is standard procedure, not an indication that you're losing, that most cases settle before trial, that defense verdicts are common, removes the catastrophic interpretations that drive the worst of the MMSS response. This is education that should come from defense counsel early in the process, not something the physician has to figure out alone.
The second is replace shame with confidence. This is the hardest one because it requires fighting against everything we were trained to believe. We were taught that if we practice good medicine, we'll be protected. So when we get sued, the reflexive interpretation is, I must have failed. But the data says otherwise. By age 65, 75 to 99% of physicians will be sued. and 62% of litigated cases involve entirely defensible care. Being sued is not an indictment of your competence, it's a predictable occupational hazard. Internalizing that distinction, really believing it, not just intellectually acknowledging it, is one of the most protective cognitive reframes available. The third is understand the drama. Dr. Andrew encourages physicians to reframe the trial not as a scientific inquiry into clinical truth, but as an adversarial legal proceeding. The plaintiff's attorney's statements are tactically designed to secure compensation, not to render a moral judgment on your character. Their job is to make your care look as bad as possible. That's not personal, it's structural. And once you understand that the courtroom is a theater of advocacy, not a tribunal of truth, the emotional sting of cross-examination becomes more bearable. The fourth is armed with tools. This means developing what Dr. Andrew calls a personal survival kit, regular physical exercise, professional therapy, and critically active participation in your own defense. And this is the one that resonates most with how physicians are trained. We are problem solvers. We are people who take action. One of the most psychologically damaging aspects of litigation is the passivity it imposes. You're told to be quiet, to wait, to let your lawyer handle it. For a person who has spent their entire career making decisions and taking responsibility, that passivity is torture. When physicians actively engage in their defense, when they review the medical records, annotate the timeline, find the literature that supports their clinical reasoning, help their attorney understand the medicine, they get something back that the lawsuit took away: agency. They're not just sitting in a chair being defended, they're participating. And that participation, the evidence suggests, is genuinely protective.
The intervention with the strongest evidence base for mitigating MMSS is peer support. In 2023, Doering and colleagues published the first study of a facilitated, group-based peer support model designed specifically for physicians named as malpractice defendants. The setting was an emergency medicine group. Physicians who were current defendants in malpractice cases were invited to participate in facilitated group discussions with other physician defendants. The key design insight was this: while the legal process requires strict confidentiality regarding specific case details, discussing the emotional impact of the case is not prohibited. The results were striking. Enrollment feasibility was high. 64% of invited physicians participated. Despite the study occurring during a period when general emergency medicine burnout was actively rising, burnout levels among participants remained statistically flat and stable. The program achieved a 100% Net Promoter Score. Every single participant said they would recommend it to a colleague facing litigation. And 96% reported feeling subjectively better immediately following the sessions.
100% Net Promoter Score in a population of emergency medicine physicians, a specialty known for being skeptical, direct, and not easily impressed. Every single participant said, "Yes, do this for other people." That tells you something about the magnitude of the unmet need. These physicians were desperate for a space where they could talk about what they were going through with people who understood it. And when that space was provided, every one of them found it valuable. And the mechanism is simple. Peer support works because it breaks the silence. It normalizes the experience. When you sit in a room with other physicians who are going through the same thing, who can't sleep, who are having intrusive thoughts, who feel like their career is over, you realize you're not broken. You're not weak. You're having a predictable response to an extraordinary stressor, and that realization by itself is therapeutic. The group doesn't need to solve the legal problem. It just needs to remind each participant that they're not alone.
Beyond litigation-specific peer support, several institutional models have been developed to support healthcare workers experiencing trauma and distress. The most well-documented is the RISE program, Resilience in Stressful Events. Developed at Johns Hopkins Hospital, RISE trains peer responders, healthcare workers who receive specific training in psychological first aid and active listening. and deploys them to support colleagues after adverse events, patient safety incidents, and other stressful experiences. The published case study describes the development process, training protocols, and implementation challenges, including the need to actively promote awareness and normalize use.
From an institutional perspective, the RISE model is significant because it demonstrates that peer support can be operationalized within a hospital system. It's not a one-off study or an academic exercise. It's a functioning program with trained responders, referral pathways, and institutional backing. And the evidence from the broader second victim literature supports the model. A systematic review found that a large proportion of healthcare workers experience second victim effects over their careers. And institutional support strategies can meaningfully reduce the burden.
I want to connect this back to the litigation context, though, because there's a gap. RISE and similar programs were designed primarily for the second victim experience, the trauma of being involved in an adverse event. They're excellent for that, but the MMSS experience is different. As we discussed in Part 1, the trigger for MMSS is the legal process, not the clinical event. A physician can have a perfect clinical outcome and still develop MMSS from a meritless lawsuit. Institutional programs need to expand beyond the adverse event model to include litigation-specific support. The Daring model shows how to do that, but very few institutions have implemented it.
Increasingly, malpractice insurance companies are offering emotional support and wellness resources for their policyholders. Michael, what's available?
More than most physicians realize, and this is one of the most actionable things I can share because these resources already exist. You just need to know about them and use them. The Doctors Company, the nation's largest physician-owned malpractice insurer, offers a video series called What to Expect from Litigation and Malpractice Case Studies, What Went Wrong. They also have burnout reduction programs. Coveries offers an emotional support program specifically for physicians experiencing the emotional impact of claims, lawsuits, or adverse events. MagMutual provides a 24/7 physician-staffed emergency hotline, online CME courses, and a peer-to-peer program for litigation-related stress. PRI, Physicians Reciprocal Insurers, offers a peer support group for New York physicians facing malpractice litigation. An Empro insurance company has featured Dr. Sarah Charles herself on their Flourishing in Medicine podcast series. Here's what I'd recommend. Call your malpractice insurer today. Not when you get sued, today. Ask them what wellness and emotional support resources they offer. Ask whether they have a peer support program. Ask whether they provide educational materials on the litigation process. And if they don't offer these things, tell them they should. Because insurers are learning that physician wellness during claims isn't just a nice thing to do, it affects outcomes, retention, and ultimately, claim costs.
The resource that most directly addresses MMSS is the Physician Litigation Stress Resource Center, founded by Dr. Sarah Charles. The psychiatrist whose personal experience with a malpractice trial in 1976 launched the entire field of MMSS research. The center's advisory group includes experts from nursing, risk management, law, surgery, and obstetrics. Its stated mission is to decrease the likelihood that any practitioner involved in or facing the threat of medical malpractice litigation has to do so alone.
That mission statement is, I think, the most important sentence in this entire series. Decrease the likelihood that any practitioner has to do so alone. Because that's what MMSS comes down to at its core. It's the loneliness, the silence, the feeling that no one understands what you're going through, that you can't talk about it, and that admitting how much it hurts is somehow a betrayal of your professional identity. The Physician Litigation Stress Resource Center is at physicianlitigationstress.org. I'd encourage every physician listening to bookmark that site right now, not because you need it today, but because you might need it tomorrow, or a colleague might, and when that moment comes, you won't have the bandwidth to search for it. It should already be in your toolkit.
Multiple specialty societies have developed litigation stress resources. Sarah, which ones stand out?
The American College of Emergency Physicians, ACEP, has been a leader in this space, which makes sense given that emergency medicine is one of the highest risk specialties for litigation. They offer litigation, stress, educational materials, and a volunteer peer support program. The American College of Obstetricians and Gynecologists, ACOG, has extensive professional liability resources and has issued a formal committee opinion on coping with the stress of medical professional liability litigation. That document explicitly addresses the vulnerability of residents and early career physicians and emphasizes the need for mentoring and support when trainees are named in claims. The American Society of Anesthesiologists and the Society for Pediatric Anesthesia both maintain wellness resources that address litigation stress. And the AMA, while not a specialty society, provides peer support, program guidance through its Steps Forward initiative and has been at the forefront of policy reform on mental health reporting.
I'd add one thing. Check your specialty society's website for litigation stress resources before you need them. Most physicians only interact with their specialty society for CME or conference registration, but many of these organizations have developed thoughtful, specific resources for members facing malpractice claims. Find them now. Know where they are, because when you get the summons, you won't be in a state of mind to do a comprehensive resource search.
Beyond individual and institutional interventions, there are structural policy changes that could reduce the burden of MMSS. Sarah, what does the evidence support?
3 areas of policy reform have the strongest evidence base. The first is communication and resolution programs, CRPs. These are alternatives to the traditional deny and defend legal strategy. When an adverse outcome occurs, CRP protocols require hospitals to proactively and immediately engage with the patient and family. The process involves transparent communication about what happened, a sincere apology if an error occurred, an offer of fair and rapid financial compensation, and an explanation of the steps being taken to prevent recurrence. The evidence on CRPs is encouraging. Research shows they significantly reduce the frequency of legal claims, lower defense litigation costs, and decrease the practice of defensive medicine. And critically for MMSS, they reduce the stress burden on providers by allowing them to express empathy, apologize, and maintain the therapeutic relationship instead of being forced into adversarial silence. The second area is apology laws. Many states have enacted laws that protect physicians' expressions of sympathy or apology from being used as evidence of liability. The evidence on whether these laws actually reduce claims is mixed. Causal inference is difficult. But they represent a policy lever that supports the communication approach underlying CRPs. The third area is mental health reporting reform. The AMA has called on state medical boards to stop asking about past mental health diagnoses and treatment on licensing applications and to focus only on current impairment. This is critical because, as Michael discussed in Part 2, the fear of board reporting is one of the primary barriers to help seeking among physicians with MMSS. States that have adopted this approach, focusing on current impairment rather than history, have removed one of the most damaging structural barriers to physician mental health care.
And I'd add a fourth area that isn't in the formal policy literature yet, but should be MMSS education and medical training. We require residency programs to address burnout and wellness, but MMSS is not a specific requirement, and yet it's an occupational hazard that will affect the majority of graduates. We teach medical students about hepatitis exposure protocols. We teach them about needle sticks. We teach them about radiation safety. We should teach them about what happens to their mind and body when they get sued, because the evidence says that knowledge is the single most protective intervention. And right now, we're sending physicians into a career where litigation is almost guaranteed, completely unprepared for the psychological impact.
Michael, let's put this all together. If a physician listening to this episode wants to build a personal MMSS preparation plan, what should it include?
I'm going to lay out a concrete plan, 7 steps Things you can do this week. Step 1, understand your malpractice policy, read it, know what type of coverage you have, occurrence versus claims made, know whether you have consent to settle rights, know your policy limits, know what gets reported to the National Practitioner Databank and when. This is your financial and legal foundation. Don't wait until you're sued to learn it. Step 2, identify your support person. Choose one colleague, one mentor, or one friend who you trust implicitly. Tell them, if I ever get sued, I want you to be the person who checks on me. This doesn't require a formal program. It just requires one phone call, one conversation, one commitment. Make it this week. Step 3, know the distinction between case details and emotional impact. Write this down if you need to. I can talk about how the lawsuit makes me feel. I cannot discuss the specific facts or legal strategy. When the time comes, that distinction will be the difference between suffering in silence and getting support. Step 4, bookmark the resources: Physician Litigation Stress Resource Center, physicianlitigationstress.org, your malpractice insurer's wellness program, your specialty society's litigation stress page, the 988 Suicide and Crisis Lifeline, the ACEP Peer Support Program. Put them in a folder on your phone, label it "If I Get Sued." Do it today. Step 5, maintain your physical health as a deliberate practice. The Maroon case report showed that prolonged litigation stress causes hypercoagulability and cardiovascular events. This is not theoretical. Exercise, sleep, and stress reduction during litigation are not luxury wellness practices. They may be life-saving. Build those habits now before you need them to sustain you through 4 years of litigation. Step 6, learn the litigation timeline. We walked through it earlier in this episode. Know the phases. Know that the average case takes 3 to 5 years. Know that depositions are adversarial by design. Know that most cases settle. Know that defense verdicts are common. Familiarity reduces fear. Step 7, advocate for change. If your hospital doesn't have a peer support program for physicians in litigation, advocate for one. If your state still asks about mental health history on licensing applications, write to the board. If your residency program doesn't teach MMSS, suggest it. Every structural change starts with one person deciding it matters.
Michael, we're wrapping up a 3-part series that has covered a lot of difficult territory. Is there anything you want to say directly to the physicians listening?
Yeah, I want to talk to you for a minute. Not as a podcast host, not as a content creator, as a colleague. If you're in active litigation right now, if you're lying awake at night going over the chart for the 1,000th time, if you're dreading the next deposition, if you've started avoiding certain patients because they remind you of the case, I want you to know that what you're experiencing is a recognized occupational syndrome. It has a name, it has a clinical evidence base, it affects the majority of physicians who are sued, and it does not make you weak. You went into medicine to help people, you trained for years, you sacrificed weekends and holidays and relationships and sleep, and now someone is telling you, in a legal document, in front of a jury, in the pages of an expert report, that you failed. That's an extraordinary burden to carry. And carrying it in silence, which is what most of us do, makes it heavier. So I'm asking you to do one thing, just one. Talk to someone, a colleague, a therapist, a peer support group, your spouse. It doesn't have to be about the case. It can just be, "I'm not okay right now." Those 4 words are the beginning of recovery, and you deserve to say them. And if you're not in litigation, if you're listening to this from a place of relative calm, remember this episode when a colleague gets sued. Be the person who reaches out. Be the person who asks, "How are you actually doing?" Be the person who breaks the silence, because the evidence is clear. The single most damaging aspect of MMSS is the isolation. And the most powerful intervention is another human being who shows up and says, "I'm here."
This has been a 3-part series on medical malpractice stress syndrome, the injury no one talks about. In Part 1, we defined the syndrome, explored the clinical evidence, and learned that the process of litigation, not the outcome, is the traumatic stressor. In Part 2, we confronted the connection between MMSS and physician suicide, a crisis that claims 300 to 400 lives every year. And today, in Part 3, we've laid out what physicians can do right now before they're sued to protect themselves, their practices, and their health. The evidence is clear. MMSS is a real, well-documented occupational hazard. It can cause psychological, somatic, and behavioral harm that persists for decades. In rare cases, it can kill. And the best defense against it is knowledge, preparation, and the willingness to break the silence.
The bottom line for this series is simple. You are going to get sued. The statistics make that almost certain. But you don't have to be blindsided. You don't have to suffer alone. And you don't have to let the process break you. Know about MMSS, prepare for it, talk about it, and when a colleague gets sued, show up for them. That's how we change this.
Thank you for listening to this 3-part series on the charted defense. If you found this valuable, share it with a colleague. Because the more physicians who know about MMSS before they experience it, the fewer who have to go through it alone. If you or someone you know is struggling, the 988 Suicide and Crisis Lifeline is available 24 hours a day, 7 days a week. Call or text 988. This is the Charted Defense. Take care of yourselves. This episode of the Charted Defense is for educational purposes only and does not constitute legal or medical advice. Medical malpractice laws vary by jurisdiction. Case details referenced in this episode are drawn from published, peer-reviewed medical literature and publicly available legal information. If you are currently experiencing a mental health crisis, please contact the 988 Suicide and Crisis Lifeline by calling or texting 988.